I'm discombobulated, y'all. I'm not drunk. I'm not high. I'm just discombobulated a little bit today. I was trying to, I was messing with some different formats. Like I reformatted this video and put in overlays and backgrounds at the same time. I'm doing all kind of stuff. I'm experimenting and shit. I'm fucking up. But yeah. There we go. I got my background going, video going. Yeah. It's just nice, All right. So we got the sound. Okay, he's saying it's an echo. Oh Lord. Oh, there's no echo? Okay. Yeah, I'm looking at it right now. Look good. Look good. Okay, look good. How the format? Y'all like the format? Y'all like the format? I'm trying to make it look, professional. Oh, there's no echo? Yeah, it look good. That look good. That's cool. Sure. Y'all tripping. Y'all ready for me to get to it? All right, let's get busy. Y'all ready to rumble? All right. This is a video I was looking at. I think this is going to be a good teaching tool. Let me see. I think this is going to be a good teaching tool to kind of demonstrate errors and then how some of the tricks and traps. A lot of times when y'all go into court and they'll just tell you, well, this don't work in court. One of the things, like I hear a lot of these attorneys say, oh, try that in court. I saw somebody get civil contempt, contempt for that. Or try that in court and you're going to prison. They like to say that. But the thing about it is, we're not trying anything in court. We're just asking a question. I don't understand what they mean when they say, if I got a Sixth Amendment right to know the nature and cause, okay, it said nature and cause. What do you mean I'm trying something? Or are you saying that y'all don't follow the Constitution? Because that's what it sounds like a lot of times when I see the comments under these videos when they say, well, you try that in court, you're going to go to jail or whatever. I'm going to try in court. I'm asking you a constitutional question and you threatening me with jail. It sounds like somebody's committing treason. It's what it sounds like to me. I can't understand it. I'm just asking you a question, man. You acting like I'm attacking you. I'm asking you a question. I got a video on TikTok, got almost 300,000 views, where it's just a clip of me saying this in court. And it's all kind of attorneys coming on talking about, you can't try that in court. I saw somebody try that in court. They got, usually they ain't gonna never show you nothing in public. And you can tell it must be something good because they come out like ants. They don't want y'all to know the truth. I'm seeing that more and more. However, we got a video review today. I'm going to review this video. I only kind of did a cursory overview of it. I haven't really looked at it thoroughly. So I'm a little bit prepared on some of the things, but, not totally. But I'm going to pause on some things and kind of show y'all some things along the way. And, hopefully, it's, hold on, let me see if I can add a couple of these in there too. Yeah. All right. Yeah, okay. That's what's up. That's what's happening. All right. All right. Okay, so are we ready to go? Okay, thank you, Wallace Shale, for the $9.99. I appreciate that, bro. Where we at on the likes? Let's get the likes up to 100. Let's get the likes up to 100 so we can start this thing. Y'all know how this goes. The likes for the analytics. If you like my channel, I appreciate the likes. I appreciate the, comments, everything. I appreciate all the donations, everything. Donations are good. Donations what keep me coming back. All right, so Let's look at this review real quick. Wait, hold on. Let me see where we at. The likes only at 58, man. Come on, let's get the likes 130. Y'all get the likes up. Y'all know we have to have the likes at 100 before I can start. I just can't do no review when just people come in and they don't even push the like button. I mean, come on now. Let's get them likes up to, let's get the likes up to 100. That's the least you could do. Likes over to 100. Where we at on the likes? We at 77. Likes just creeping up. Trying to get the likes up to 100 so we can start. Make sure I got all this. Yep. All right. All right. Good to go. 84. Get the likes up. 95, only need 5 more. And then we can start going one. Okay, there we go. Appreciate it. Thank you. Let's get started. All right, let's look at this right here. Let's see what's happening with this video. Doing a video review. Sovereign citizen fails in court. Okay, they say this judge obliterated this man in court. Let's do a real review of it and see what really happened. All right, let's get going.
All right. Well, I find that Matthew Neil Aldridge has failed to appear in personally in this court for the plea day on his case, which was set for trial. All right. Good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, right. His authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent mayor.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statute. And what does that mean?
You know, right. His authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Okay. First of all, when you do these video reviews, you can begin to understand why they call you sovereign citizens and why shit sounds crazy to them. I really understand after doing these videos. Now, I understand what he's attempting to do. Now, Dean Clifford, I don't know if y'all remember who he is, but if you can, get on the internet and check him out. He was one of the first people, you know, I give him credit, to come and talk about you know, this thing about the name in court. His name is Dean Clifford. I remember I used to watch his videos. And I like what he was saying, how the name is not important. It is the position that the people are occupying, which I agree with. A lot of y'all get caught up too much on that name because you feel like you're giving someone jurisdiction just by giving your name. Now, in the public, they got something called alerting the public. One of the things that they have in Louisiana is called an affidavit of denial of corporate existence. Okay, I would suggest that people start putting that in the case. Just Google Louisiana affidavit of denial of corporate existence. They got one with Don Quixote's abatement at common law. There's one in there if you want, and just, just print it up and stop going into court afraid to answer to the name. That way you already had on the record an affidavit attesting to the fact that you're denying the corporate existence of a legal entity, of which they would have to, come back and put in a counter affidavit asserting that a legal entity does exist. And we do know that silence is acquiescence. I think people, what you need to do to become good at this is you have to learn ways not to alert the public, not to put something on public display, because they're always 100% of the time going to make you look stupid or try to make you look stupid. Now, he's saying that he's the attorney in fact. Now, also, in One Man Out and other documents, they actually have a power of attorney for the straw man. That is part of some people's actual status correction, is to include a power of attorney for the straw man. So you can put so you can put that on record as well. And then that way you could have said, yeah, I have a power of attorney. But the conundrum or the hurdle that you're going to have to get over is, first of all, in the public, they do not recognize the fact that you and the all caps name are two distinct entities. They're going to always challenge you on that, which that's really not the issue. When you do a secure party process, in your paperwork, you've already told the government that you are going to accept all the liability associated with the straw man. So there's no need to get into an argument with them. Additionally, the straw man is a 14th Amendment citizen, not you. Not you. A lot of Moors, they say, you're trying to say I ain't never said that you're a 14th Amendment citizen, because everything in the public is an artificial person. The straw man is a 14th Amendment citizen, the all caps name. And a part of the contract of a 14th Amendment citizen is you cannot question the public debt. That's in the 14th Amendment subsection 3. Okay, the public debt shall not be questioned. So when you come in here and this is a debt collection and you're questioning the debt, they're doing this for what? To pay back. The underlying thing under all of this is the national debt. You got to understand that. You can read Byron Beer's What Does Acceptance for Value Mean? It's a technical read, but it's a required read for you to understand and get the essence of what is going on. A lot of you are just interested in just getting some sort of remedy because you have some sort of exigent circumstance that you're trying to eliminate. I can tell you right now, you're going to have a lot of problems with that because you don't respect what it is, this information, enough to take the time and actually learn what you're doing. You're trying to come in and just somebody told you what to say, and you're coming in and saying it, and it's very evident that you're coming into court doing something that somebody told you to do. If you go back and watch The Matrix, the Merovingian, when Neo, Trinity, and Morpheus come to see him, and because the Oracle sent them to go see him, and these people tell you things in movies. He said, go back to the Oracle. He said, you're here because somebody told you to come here. You're doing what somebody told you to do. You don't know what you're doing. You can't be a sovereign if you're doing what somebody told you to do. That's why I started a school, so you can make your own decisions. I'm not trying to tell you what to do. I'm trying to teach you how to think for yourself. Now, so when you come into court and you start talking to this man like, I'm the power of attorney. I'm attorney in fact. Okay, you just creating a controversy for no reason. Let's do something simple. It said, yes, Jan, and for the record, my name is not styled in all capital letters. I would prefer this court reference me with the Christian appellation of my name and then spell it out. For the record, capital J, lowercase o, lowercase h, lowercase n, capital D, lowercase o, lowercase e. For the record, Jan. And just keep it going. And I'm here concerning that matter in question. And let's keep it going. Let's not make an issue of a big issue too much. If you're just so overly concerned about the name. Okay, now, this is challenging jurisdiction. I don't really suggest people challenge jurisdiction right out the bat, but I'm doing a review of a video. okay, where people like to come in, because challenging jurisdiction is probably the biggest thing that people like to do. They like to come into court and challenge jurisdiction. Most of the videos that you see on YouTube are going to be someone coming in challenging jurisdiction, which I find that quite interesting, that you're trying to challenge jurisdiction when the jurisdiction of the court never was revealed to you. They never told you how you going to challenge something and it's not on the record what it is. I'm just saying. There's something for you to think about. Okay, you're making conclusions of law. When you have to understand is that you got to get them to testify. That's why the most powerful weapon that you have is asking questions. Because, okay, anything you say can and will be used against you. It's not just go for you, it goes for them too. Equality under the law is mandatory. What goes for you goes for them. The person asking the questions is the one that's in the power seat. The person answering the questions is in the inferior seat. Now, granted, when you answer a question, you have made an appearance. However, but you can't just say, well, yes, I'm here by special appearance. And then leave it at that. You don't have to keep repeating that. Just make sure, for the record, John, I'm here as special appearance, making a special appearance with a specific purpose. All right, with a specific purpose to establish on the record the nature and cause of this action. It's something like that, okay? But come on, let's get away from some of the things that y'all are doing out there. Y'all doing things that people have been doing for the last 20 years. You don't think they're not ready for that? You're doing things that have been done for the last 20 years. Y'all, I'm seeing this stuff that y'all doing in court, people been doing for 20 years. They've had meetings behind closed doors. They got a book that they put out and publish talking about all the things you come into court with. Are you serious? I would think that you're stupid too, because you're not prepared. You haven't contemplated that he's ready for you. And you come in with the same thing that a million other people came with in front of you. So let's look at this. Another thing, all right, so let's try to stay away from that. He said you're the attorney in fact. All right, I'm an attorney in fact. And remember, I just gave you some resources for you to look up if you want to go that route. Okay, we can look at what an attorney, a power of attorney looks like in our process. But let's not get caught too much up on the name, all right? Let's just try to establish it's public and private. It's a debt collection. We're trying to find out the nature and cause of the action, and then we're trying to go for settlement and closure. We're not here to engage him in any issue of fact. When you start arguing, okay, you are going into their territory. That's why they like to say, well, you're making an argument for the argument you're making. I'm not making an argument. You need to stay away from arguments. You need to do what it says in Matthew 5:25. Agree with your adversary while you're on the way to court, lest he hand you over to the judge hand you over to the bailiff, and the bailiff casts you into prison. I tell you, you will not come out until you pay the very last farthing. Farthing means a percentage of a penny. They're going to put you in hell. Hell is debtor's prisons. All right, so let's keep looking. Let's see what else we can dissect from looking at this. Also, pay attention when you do an objection. On the last video, the judge said, he objected, and the judge said, your objection is noted. That is not an answer. I missed that. And I had to tell y'all that. He said, your objection is noted. I'm like, no, you say, Your Honor, I take exception to the honorable judge's refusal to rule on my objection. Would you please enter sustained or overruled into the record so I can preserve the error? You make him commit on the record, either sustained or overruled. If you don't do that, the appellate court is going to assume that your silence means that you agree. It's you need to read a document called Court Tricks and Traps. It's the best 4 pages you will ever read. Okay, let's get back into this. Let's get back. All right, let's get back.
Pardon?
And I'm the attorney at fact for the respondent mayor.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't the court just let me file this document?
Show it to the bailiff and he'll show it to me.
I'm supposed to have a copy of it.
Oh, apparently there's a copy here.
Yeah.
All right. This is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking.
Okay. This is another thing I see with a lot of people going to court. You don't have proper courtroom etiquette, which is never going to work in your favor. Okay. I want you to think in terms, when you go to court, you should have on a suit. You should have on a suit and you should be a gentleman. Okay. All this interrupting the judge and all this damn heathen type things that you do in the court, interrupting the man. One of the rules is that you have to stay in honor at all costs. What that means is you have to honor the judge, you have to honor the prosecutor, because when you go into dishonor, you lose. I know that's a concept that may be strange to some of y'all that are in this space, but that's only because you're not thoroughly learned in this particular subject matter. Okay? You need to learn how to do proper courtroom etiquette. Let the man started reading, let him finish doing what he's going to do. Don't interrupt him. That way, when he starts interrupting you, you can say something to the effect, "Objection, Your Honor. I would appreciate it if this court would allow me or extend to me the courtesy of making a record as I have to this court. I'm trying to make a record for appellate purposes, and the judge keeps interrupting me. And I would appreciate it if you extend the same courtesy of allowing me to make a record as I've extended to you. To get equity, you must do equity." Okay. Let's keep going.
Okay. This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Penal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the.
Okay, I see we have some people in the chat talking about you having the authority. Okay, first of all, you're stupid. Okay, it doesn't matter if he doesn't have any authority. You're not going to get anywhere being a stupid asshole. You got to learn, this is court. This is law, okay? This forum has a certain decorum that you have to abide by. All right? You just don't come in here acting a damn fool. That's all I'm talking about. It doesn't matter if he doesn't have any authority. You're still there. You done came to court. You in the courtroom. You came into their jurisdiction when you came into the court building. What are you talking about? They don't have no authority. They got guns. See, you can always tell a person that ain't never done this shit for real in court or been locked up or nothing, because they talk in terms of fantasy. They like, when I talk, I give you the reality. You can be right and still get fucked up. These people will still fuck you up. You have to respect their power. And they don't have to prove anything. Look at this. Look at this. Let me tell you something. I heard this right here lets you know, equalize the time. They must prove jurisdiction. If not, there is no case. That phrase right there, people have been saying for the last 25, 30 years, and it never wins. These people, they talk like that. He think he's saying so. I've been doing this 20 years, man. I've been doing this 20 years. You think you put that in all caps, you think you saying something I ain't heard a million times? We know you can challenge subject matter jurisdiction at any time. We know that they have to prove jurisdiction. You know how many videos I've reviewed where people have put into the court, well, you know, I'm going to do Moores in court next and show you when they were in court saying that, you know, you have to prove jurisdiction and you can't proceed forth with the case. It's something that the definition of insanity is to keep doing something over and over again, hoping for a different result. If you're doing something, they preparing for you. This judge is prepared for him. He didn't went to a meeting. He's ready for everything. He didn't even read what was in his document. So it didn't even make the record. You're going to get fucked over procedurally. And you're in there asking questions, talking about they ain't got jurisdiction. As soon as you open your mouth, you made an appearance. Because the definition of a public figure is one who voluntarily participates in a public controversy. Let's look at this.
All right. Well, I find that Matthew Neil Aldridge has failed to appear in personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result,
This is technique. They used this technique on me in 2010. Let me just show you how far back ago I did what this guy just did. I did that thing, challenged the name, walked out of the courtroom. They say he didn't appear. He ain't made it. Because this is how because at first they didn't have nothing for the name. You said, well, I'm not that name. They didn't have nothing for that. They went into a meeting and they said, well, if they're going to answer to the name, just say failure to appear. Give them a failure to appear. I walked out to the courtroom. When I got down in my car, the sheriffs met me downstairs, arrested me, walked me back upstairs, and walked me through the courtroom to make sure that everybody saw I got arrested and took me to the back. See, what y'all don't understand is I done got arrested plenty of times. I done went through the arrest, release. I done did all of that type of stuff. I'm not sitting up here trying to give some sort of impression. Hear the magic words. You just say them and you magically walk out of the courtroom. You know, it's dumb shit. You know what I'm saying? And y'all please don't talk to me. If you're a person been doing this like 3, 4, 5 years, just remain silent. Reserve your comments. You haven't been doing this a long time. You don't have the requisite experience to be commenting on something. What you're talking about is theory. If you've never been in court and put this into practice and succeeded, then what you have is a theory. Okay, if you've never been arrested, I'm going to tell you something else. What we used to say back in the old school, you ain't no sovereign until you've been in front of a judge. You ain't no sovereign until you've been in front of a judge and tested your skills and your knowledge to see if all the things that you know is correct, and also to see whether or not that you have the fortitude to actually proceed through with something. Thank you. It's all about respect. This guy talking like, you don't have to respect them. They're going to fuck you up. You can tell somebody been in prison too. When dudes who've been in prison, the number one thing we come to understand in life, any nigga that been in prison understand this. The number one thing you come to understand when dealing with other men or dealing with anybody is you learn to respect everybody, because somebody will fuck you up. You could be the biggest dude in prison, 250 pounds solid muscle, and a dude damn 5'5" skinny will kill your ass for disrespecting him. You respect everybody. You respect the court. Ain't nobody telling you to kiss their ass. Respect don't mean kiss somebody's ass. Respect means allowing him, he started reading, let him finish. Then respond. You're not there to talk to the judge anyway. You're there to make a record. That's another mistake that you make. You think you're there to talk to him. You're not there to talk to him. You're there to talk to the record. You're making a record. All right, let's go.
Have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are, in fact, Matthew Neal Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited.
Now, after getting on his ass, it's time for me to get on the judge's ass. All right. This is what I was waiting for. All right. He's sitting here saying all of this. All right. So we're going to look at this. This is a penal action, a criminal prosecution. All right. Criminal prosecution. Okay. Okay. Penal action. A civil proceeding in which either the state or common informer sues to recover a penalty from a defendant who has violated a statute. Although civil in nature, a penal action resembles a criminal proceeding because the result of a successful action is a monetary penalty intended like a fine to punish the defendant. Penal action. At one time, it was a frequent practice when it was desired to repress some type of conduct thought to be harmful, to do so by the machinery of the civil rather than the criminal law. The means so chosen was called a penal action, as being brought for the recovery of a penalty, and it might be brought according to the wording of the particular statute creating the penal action, either by the Attorney General, which is all these criminal cases are brought by the Attorney General or the Assistant DA, or the Assistant District Attorney or somebody like that, on behalf of the state or a common informer on his own account. A common informer was anyone who should first sue the offender for the penalty, and it could be a private citizen. Penal actions are still possible in a few cases. This is what they say. Now, this is where you got to be careful, because this is very general what they're saying. They're not being specific. You say it's still possible, and their existence renders invalid several suggested distinctions between civil wrongs and crimes. So right here, the reason I took time to read this is because this judge is wrong, okay? He's trying to say, well, this is criminal, it's not civil. There does exist a particular action in which it can be criminal and civil, and that is admiralty, admiralty maritime. Admiralty has a criminal aspect to it that is civil in nature, and it's colorable. When we say colorable, they like to say, well, admiralty is the law of the sea. But that's because it's colorable, because it's being done by the legislature. I don't know. We trying to still figure out how the legislature got admiralty jurisdiction, but they're doing things colorably because they're in a colorable court, because we're dealing with colorable money. These are actually Federal Reserve courts because they're using Federal Reserve money, and Federal Reserve is not a constitutional entity. Now, if you're an attorney out there and you think that they are, then you prove it to me. Show me in the Constitution where the Constitution gave anyone the authority to have something called the Federal Reserve. They didn't. What it is you have the Federal Reserve Act, and that was under their plenary power. Now, I've done a lot of research on this plenary power of the legislature under Article 3 and Article 2. And what's really interesting, they are got all type of professors. And here's the thing, y'all attorneys don't even know. Y'all really don't have a clear understanding between Article 1 and Article 3. You don't. And the reason you don't is because you don't understand something as simple as separation of powers. I'm really beginning to question some of this so-called intelligence that a lot of you have. Penal action. For in penal actions, unless the statute expressly authorizes private persons to act as informers, the state alone can sue and recover the penalty, and yet there is full authority for ranking such suits as merely civil proceedings. Okay, got another one. Okay, current with the changes from legislative, corporate existence presumed. Okay, now this right here, this is what I wanted to show y'all about in Louisiana, the Louisiana statute, okay, where you can put in what is called an affidavit of denial of corporate existence. Now, this is really interesting because it's in Louisiana. It was found in Louisiana, but it's something that's very interesting that, okay, like why in Louisiana you have a criminal proceeding that they have the right to presume. You got to understand, they operate on presumptions, assumptions, and color of law. So if there is some sort of unstated presumption, you can't rebut an unstated presumption. So forget what these attorneys are saying. It would behoove you, I think, in any criminal proceeding to go ahead and put in an affidavit of denial of corporate existence just to cover your bases. That should take care of this all caps name where you don't have to go in there and start arguing, well, that's not my name and all that. But right here, you can see corporate existence presumed unless affidavit of denial filed before trial. Okay, and this is Louisiana Statute 15, subsection 429. On trial of any criminal case, it shall not be necessary to prove the incorporation of any corporation mentioned in the indictment, unless the defendant, before entering upon such trial, shall have filed the affidavit specifically denying the existence of such corporation. Now, I'm going to tell you, all of my research into this Article 1 and Article 3 has just revealed to me that the legislature, they only have authority over corporate matters. It's all business. And they converted crimes into commercial crimes. That's why you have a UCC, all crimes are commercial. 72.11, 15 USC 72.11, Code of Federal Regulation, 27 CFR 72.11. All crimes are commercial. Okay, let's look at that. Let's look at this. There exists a well-known class of proceedings called penal actions by which pecuniary penalties can be recovered, in some cases by any person who will sue for them, from the doers of various prohibited acts, these acts being the prohibited and visited with penalties, solely on account of their tendency to cause evil to the community at large, considered as community. So right now, we're getting into it, okay? Let's see, 10. Now, this is what I want to show you too. When I was studying this stuff between Article 1 and Article 3, and this goes on all levels, this Judiciary Act, now the states follow this too. So I'm doing it on the federal level, but the states follow this too. They had a Judiciary Act of 1789 now that created the United States Supreme Court. Now, all this conversation, when I'm reading the United States analysis and interpretation by the Supreme Court and all these law reviews from Yale and Princeton and all these different law schools where all these people are trying to come and understand, okay, well, the Constitution created the Supreme Court. How did a Judiciary Act create a Supreme Court? This is why there is called the Supreme Court of the United States of America and United States Supreme Court. Everything that is legislatively owned, it begins with United States. United States citizen, United States Supreme Court, United States Postal Service. That's all you got to look for. It starts with United States passport. That's their stuff. So you got what's called a delegation of powers doctrine. And a lot of the early Supreme Court justices were questioning this. They were saying, well, how can one man wear two hats? It seems like there is a conflict of interest because they're two different offices. But what it is that the legislature can delegate authority to Article 3 to come in and act as administrators in their courts. All they have is appellate jurisdiction review of their cases. I understand how they set it up. They gave the separation of powers, that the legislature is not required to let the Article 3 review their cases. They don't have to, but they do it. They just want to give the appearance to everybody that there's some sort of true justice in the American way, but they don't have to give them that power. This is why it's important for us to understand how the court system is set up. I'm reading this stuff day in and day out. The attorneys don't understand. Go to an attorney and get them to try to explain this to you. They don't know. I'm reading these law professors. All this weekend, I've been reading their stuff, and they got a good grasp of it too, but it's like, I'm going to tell you the truth, man. The original drafters of the Constitution, they fucked that shit up. They have about, well, this is a genius document and all this. A lot of stuff in the Constitution, them people wrote that stuff, they seem like they were bumbling idiots. They wrote things in the Constitution that don't have any clarity to it. And they've been struggling to try to decipher it. And they'll sit there and tell me, well, do you understand the Constitution? You don't understand it. Your law professors don't understand it. But I understand the principles behind it. What I do understand is an Article 1 court cannot exercise the same powers as an Article 3 court. And that the powers that are delegated to the legislature are in Article 1, Section 8 of the Constitution, and those are the only things that they can adjudicate. And every time that I look at an indictment on anybody on a criminal matter, it always has some clause in there that says that you violated interstate commerce. This plenary power is a thing that you got to concentrate on that word and become very, very familiar with that word. Okay, what is jurisdiction? Jurisdiction is the power to declare the law. Everything that I'm showing you right now came out of the analysis and interpretation of the Constitution. All right, so we're going to read over this. Congress need not give this court any appellate power. It may withdraw appellate jurisdiction once conferred, and it may do so even while a case is sub judice. Sub judice means while it's going on in the middle of the case. Under judicial consideration and therefore prohibited from public discussion elsewhere. The cases were still sub judice. I don't know if I pronounced that correctly. All right, penal action. All right, right here, another one. A civil proceeding in which either the state or a common informer sues to recover a penalty from a defendant who has violated a statute. Although civil in nature, a penal action resembles criminal proceeding because the result of a successful action is a monetary penalty intended like a fine to punish the defendant. So right here, we got these penal actions. They look like criminal actions. Everything looks exactly the same. You wouldn't be able to tell the difference. That is why they put in the Constitution under Article 6, the Sixth Amendment, the right for you to know the nature and cause of the action, because you could be in the middle of an action, you don't know what kind of action it is. All right, let's get back. Now, with that being said, he's, I just wanted to put that bug in your ear because now you're going to hear, now listen to him talk about, well, this ain't, this is criminal. This is not civil. This is why you asked the question, well, Your Honor, is this civil or criminal? Well, it's criminal. Okay, thank you, Your Honor. Let the record show that the action being brought against the defendant is a criminal action. Now, sir, I have another question for you. The Constitution for the United States of America only grants this court 2 criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Now, sir, for the record, would you please tell this court and myself under which 2 of these criminal jurisdictions this court is trying this criminal matter? I hope y'all get that. He called me a ghetto scholar. Let me address that because dude said ghetto scholar. Here's the thing about it. All of your Abraham Lincoln didn't go to law school. A lot of your early lawyers, they didn't go to law school. And here's the funny thing about it. You call me a ghetto scholar, but you know that they'll call you, they'll say ignorance of the law is no excuse. The law is not the sole province of attorneys. That's something that they done fooled y'all dumbass with. You supposed to be studying this. I'm far from ghetto, homeboy. And I'm sure I got way more money than you. Because I wouldn't be coming in to calling anybody ghetto. I'm sitting here showing the people things that your sorry, lazy ass wasn't going to, well, you're not going to do anything. You come in here calling somebody a ghetto scholar. The people are supposed to know the Constitution. How are you going to have rights and you don't know what they are? If you don't have no rights if you don't know what they are. Ask yourself the question, why they ain't teaching this in high school? If you're supposed to know what your rights are, why isn't law being taught from kindergarten? It should be called, that's why you need to start your own schools and start teaching this stuff from a very early age. Because young people used to know this stuff 14 and 15. I bet your ass don't know nothing I'm talking about, do you? Probably never read the Constitution. Somebody come in and start talking about some shit. You ain't never even picked up a book, even read the fucking Constitution. Be the first one talking about my constitutional rights. And you probably don't even have a grasp of the English language like me. That's why I can proudly sit up here and say, yeah, I've been to prison, but I can spit bars with the best of them. I can sit in a corporate meeting and I can go hang out in a trap. I could do both, can you? And you know what else? Women love that shit too. Can you do both? You probably motherfucking go in a trap and can't breathe and shit. All these guys in here, these ghetto guys in here. Nah, I ain't giving no props. I'm not ghetto. I'm far from ghetto. I'm very classy. You meet me, everything about me is class. Where I live at, I got books. I got books all over the place. I got big screen TVs. I drive nice cars. I wear the best perfume. Wear the best clothes. There's nothing ghetto about me. It's nothing but somebody might not like the gold chains. You might not like, but I like gold. If you want to call that ghetto, I mean, hey, I love gold. Because I understand gold is money. Diamonds ain't worth shit. Diamonds are worthless. All right, let's keep going. And somebody asking me about a case as if I read the case. How you going to ask me about any thoughts on self versus Ray like I read it? Come on, man. Think, man. I haven't read no case. I don't have no thoughts on nothing. I ain't read it. I haven't read it. Let's get back. I had to address a few things. All right.
So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on a what we call our last plea day before his trial date tomorrow.
Question. Is that an Article 3 trial?
To what?
Will that be an Article 3 trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be.
Now, I want you to look at the body language of him, how he leaned back in his chair when he said, is there going to be an Article 3 trial? He leaned back, and notice how he kind of evade answering it. Oh, it will be a jury trial. He still didn't answer the question. Is it going to be an Article 3 trial? I want you to watch his body language.
But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before.
Notice how he snaked his way past that question. He says, it's going to be an article. Usually, when you ask them, is this going to be an Article 3, Article 1, Article 3, they'll try to give you some sort of contempt for saying that. I don't know why. That's why you got to use some sort of surreptitious way of doing it. You know, you got to sneak it in on him and hit him blindsided with him. But you see how uncomfortable he got it. You gut punched him right there. Was this going to be an Article 3 case? You know, they don't want to get into that discussion. Because as a private citizen, I should only be taken before a judicial court. I should be subject to judicial power, not legislative power. This some sort of commercial court. I need to get to, and see, for all of you, an attorney out there will tell you, try that in court. I bet you it doesn't work. Well, what do you mean try it in court? I'm asking, I'm not trying anything. I haven't tried anything yet. What I'm attempting to do before I try something, I want to find out the nature and cause of the action. I can't try anything until I know what I'm dealing with. So before I try something in court, I'm going to ask a question. I need clarity. I'm trying to find out, okay, what type of court am I in? What type of action is this? The reason they don't want you to know is civil, because that means it has to do with money. The reason they don't want you to know it has to do with money, because they don't want you to know what business that they're doing behind the scenes, as well as the fact that there isn't any lawful money, and it would disrupt their entire system. It would disrupt their entire system. But it's time for the truth to come out. We're in the age of information. They're going to have to change their system because they got too comfortable and too corrupt in it. It's a corrupt system. And it's time for change, but it's only going to change when the American people wake up. That's the only time it's going to change. It's not going to change any time before that. It's Article 3, Section 2 of the Constitution. And you need to get a Supreme Court analysis and interpretation and let the Supreme Court justices explain it to you. Now, if you like, I'll do a class on it. Because I can show you. He's saying, hey, use of peace, what is it the Constitution explicitly grant the criminal jurisdiction you're stating? It says admiralty and common law. Okay? Doesn't say criminal. Admiralty has criminal, and common law has criminal to it. Those are jurisdictions. You don't explicitly say it. It say common law and admiralty. That's why I said, is this civil or criminal? He says criminal. Okay, well, the Constitution's only criminal jurisdictions is only in common law, admiralty, maritime. That's it. That's it. You know what I'm saying? Ain't no criminal in equity. You can use deductive reasoning and come to the conclusion. If you can't understand what I'm saying, and this should be so simple. This is why they won't answer the question. Because it is simple. It's just simple. You use deductive reasoning and come to the conclusion. Okay, well, is this civil or criminal? Okay, it's criminal. Well, we move equity out the way, so we're dealing with either common law, admiralty, maritime, because those are the only ones mentioned. Common sense is that sense by which no other sense makes any sense at all. My American history teacher used to say that all the time. Common sense is that sense by which no other sense makes any sense at all. I'm like, what? He make you just think about it. Let's get back.
Tomorrow, and as a result, similar things ought not to be authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't we court just let me file this document?
Show it to the bailiff and he'll show it to me.
Have a copy of it.
Oh, apparently there's a copy here. All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are, in fact, Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding.
Okay. There's a lot to unpack that last part he said, because a lot of it didn't mean nothing to me. Okay. He's talking about, notice that he mentioned, he said, we're empowered by the Constitution for the United States of America and his state constitution. And what is it? I forgot what state it was, for the state of whatever state they're in. Now he started for the state of. This is the tricknology, as the Honorable Elijah Muhammad would say, the tricknology that they use. The state of Delaware, state of Texas, state of Florida, state of Texas, state of Georgia. Okay, that right there means something. That's not the Republic of Texas, not the Republic of California. It's something different. It's an entity, and you have to listen to the words that they use. They're carefully crafted words that have a meaning. Also, he started to get incensed after he started asking, okay, is this an Article 3 court? It's going to be an Article 3, is it going to be, he never answered that question. And that's what I want you to pay attention. See, when you look at other reviews on the internet, the guys in there are stupid, and that's why I always come behind them and do a review. Because what's happening is they're trying to make the mistakes of the judge, they're trying to gloss over it. and make it look like the individual that's in the court asking the judge question is a foolish individual. He's not a foolish individual. He may not be polished. He may not understand things and everything, but he has a basic understanding of what he's attempting to do. And he also has a rudimentary understanding of what his rights are. And he has a right to assert those rights. And what I find very disturbing is when I see public officials at the mention of someone talking about the Sixth Amendment, and you sitting there telling me that if you try that in court, you're going to get contempt. I have yet to understand how that can occur, sir. If I'm asking you something according to the Sixth Amendment and you're getting upset, that is cause for concern. Wouldn't y'all agree? Wouldn't y'all agree? So you have to look at the words that they use. See, they understand that the layman, the general population, the people who aren't involved in this, never have picked up a Black's Law dictionary. Most of them don't have a good understanding of basic grammar, the rules of English grammar, or anything like that. And they just listen to something. He sounds crazy. And a lot of them, this video has almost 280,000 views in 4 days, and 11, probably like 11,000, I forgot how many comments. I use the same to watch what happens. I have a program where I can look at their video, see all of the keywords they used. I use all the exact same keywords and everything from that video for this video. Watch this video, don't get as many views as that video, because they suppressing this channel. This is why I tell you, y'all got to share it and put things out. I got almost 70,000 subscribers, and it's hard for me to get 10,000 views. I don't understand that. How all my subscribers are not looking at these videos? They suppressing them, but they promoting that video over there. 280,000 people. TikTok just got me. I slipped through TikTok. I caught TikTok off guard on one of my videos, and I got a video on TikTok. If you go over to my TikTok, it's at Yusuf_L_19. I got a video, got 272,000. It done slowed down now. That was in 1 day. 1 day. I reposted the second part to it. That video used all the same information. It only got 800 views. It only got 800 views. They coming behind and suppressing. They're reporting like, hey, you got to suppress this right quick. But it already got out to almost 300,000 people. And a lot of them are coming over to this channel. You're not going to stop anything. You can slow it down. All y'all out there trying to suppress me, y'all been trying to suppress me for a long time. If what I'm saying is irrelevant, then why are you suppressing my channel? Why are you trying to stop me? Just let me talk and let the people decide. It's not your responsibility what the people listen to. There's an eclectic selection of people that listen to me. Everybody's not stupid. As a matter of fact, I would say that the majority of the people that listen to my channel are more intelligent than a lot of you that are in government, because y'all bumbling idiots. Because right now, y'all done voted Joe Biden ass in office. Y'all giving $300 billion to Ukraine. We $3 trillion in debt, and you have the audacity, the unmitigated gall to come over my channel and tell me what I don't understand? Boy, if you don't get off my channel and get your ass to work. Y'all look like damn fools. Y'all can't even run this country. And you know what's funny about it? All y'all are attorneys. And you know what else? I know why you want to get rid of Christianity, because the Bible warned us about attorneys. The original 13th Amendment did not allow attorneys to serve in government office. Yes, you can get a copy of it. I think it's in Colorado. And now I see why. Your governor's an attorney. Your president is an attorney. They didn't like Donald Trump. You know why? Because he was not an attorney. He wasn't in the club. He wasn't in the club. They don't like that. Stop putting these attorneys in office. Start putting men and women as your constituents from your neighborhood. Stop allowing these people to select your leaders, and you start choosing your own leaders. Because they go straight up there on Capitol Hill and start selling out. And that's what you're looking at when you look in the comments section. You're looking at people trying to suppress the truth. The United States District Judge stated it's criminal and not admiralty. Then I asked for a specific discovery, and Judge stated there is no warrant. I don't know what exactly. Thank you for the 1999 Al Hansard. I don't know exactly, but what you mean by that. But you can ask. Just start. They say, well, it's not admiralty. It's not admiralty. It's a colorable admiralty. If you listen to what I'm saying, I never said it was admiralty. Something that is colorable is not specifically that, it's in the nature of it. It's a colorable admiralty jurisdiction. It's not admiralty specific. And admiralty, when you study it, is not just the law of the sea, like they try to make. When you get clerk's practice, they explain it to you. And there's a plenty of case law to substantiate this. Where do you get the case law? The secret, what is it? Let me put the link in. Y'all read this, the baddest document with all the case law in it. If you want to shut down all this, well, admiralty is just the law of the sea. It's just the law of the sea. That's what they'll say. I've been saying that. I'm like, look, fool, I understand that, but you just haven't studied the subject. And that right there, I saw a black lady, an attorney, she said that lets you know when the judges be on the bench, they say they don't know. See, the thing about it is, y'all give these people too much credit. They operating under a reputation of being intelligent. It's a reputation. Once you start learning this stuff, you'll see, you don't even know, you haven't even read this yet. You don't even know what the fuck I'm talking about. They just come to work like everybody else. And majority of the cases that they take care of is just like McDonald's, just like serving burgers, It's just like put the bun on, put the meat on, but then you come through with somebody with a special order, well, that ain't on the menu, sir. Let me go talk to my manager. You come through with something different, Anyway, if you go over to, you go to SBC University. Let me put this in the chat for y'all. It's called the Secret Maritime Jurisdiction Exposed. This is a bad, I did about two videos on it. But if you want to kill anything, if you're an attorney, I want you to read this too, because y'all watching this. Because y'all like to talk about case law and all that kind of stuff. All right, here it is right here. It's in the chat where these judges explain to you how this admiralty jurisdiction has been encroaching upon the land, as well as the fact it's dealing with traffic, all of this kind of stuff. These judges explain it to you. When you read law, man, it's very, very interesting. It's not just so simple how they try to make it seem like, oh, this is criminal, this is civil. Oh, this is not, these statutes. No, this don't have anything, admiralty don't have anything it's not that simple. Things shade into each other. They shade into each other. And because you don't have a law degree, they try to use that against you and try to discount your intelligence. And a lot of times, you're more intelligent than they are. It doesn't mean there are some very smart attorneys. I don't want to down all of them, but as Judge Warren Berger said, he said about 51 to 60% of y'all are incompetent or corrupt or both. That's what the man said about you. Now you can Google that. Anybody can Google that right now and pull it up and see it for yourself. Warren E. Berger. Judge Warren E. Berger. And they put him under fire for saying that, but he didn't come off of it either. Because Supreme Court justices, I don't have no problem with Supreme Court justices. I don't. I read their opinions, and they are legal geniuses and geniuses of the law, and a lot of them deserve their position. Sometimes I think they're very, they use a lot of surplusage in their opinions, and in my opinion, and they go all over the place sometimes just steady getting to the point. And sometimes I think they very craft their opinions in such a way to avoid revealing certain things. But if you are, if you're astute enough, you can see, they do leave you breadcrumbs, and you can see what it is that they're trying to tell you. Yeah, I encourage people to read case law. I've been saying, anybody knows me, I've been saying that for like last 7, 8 years. That's when I started changing, when I started reading the case law. See, a lot of people say don't read the case law because they think the judges are corrupt. The judges are not corrupt. The judges are only making decisions based off facts that have appeared. Sometimes they'll take the time to educate you on a particular point. Sometimes they'll take a time in a review just to teach class. That's what I like, when they start teaching class. They say, you know what, I'm tired of this shit. Let me, in this opinion, I'm gonna teach y'all some shit. They'll do that, and it's very good. So I encourage a lot of people to read case law, and shout out to Byron Beers, because I started reading case law because in that document, what does acceptance for value mean? He said there's a lot of remedies in case law. And he's right, it is. Stop thinking everybody's corrupt. Everybody's not corrupt. For instance, Clarence Thomas is not corrupt. That's why they don't like him. Because they don't like Clarence Thomas because he see what's going on. You can read his opinions and you can see what he's trying to stop and what he's trying to do. He's trying to honor the Constitution, along with Scalia before he mysteriously died in Texas. Scalia was one of the best judges we had. They almost had, if they would have elected Merrick Garland to the Supreme Court, we would have had 4 Democratic Jewish judges who were liberals on the Supreme Court. And they got, and Trump bypassed him, and they got Amy and the other guy. Both of those 2 guys, they both Christian. Look at their religious affiliation. The last 2 individuals that were affirmed to the Supreme Court. And go back and look and see. And they put a Merrick Garland as your attorney general, and look what he's been doing. Just look at the individuals and what they've been doing. This is something that anybody, what the problem with all of you is that you're not looking, and this is what really gets me about Moorish individuals. They want to look at talk about black, but they don't want to look at nobody else's nationality. They pay attention, they keep talking about you claim your nationality, but they're not looking at the nationality of other individuals that are in public office or the people that are attacking them. All white people are not the same. Some of them are Scottish, some of them are English, some of them are Jewish. They not the same. And they all and they're all different. And they all don't like each other. They ain't all on one accord. Y'all got to stop this, man. You got to stop this. That right there is always going to put you in a position where you ain't gonna never make any headway of anything because you're allowing your own personal prejudice to hold you back. You got to get rid of this prejudice. You got to get rid of that. You got to get no one wins the race in racism. You got to get rid of that prejudice and I'm greater than you and all that. That's why I don't really buy into the Moorish doctrine too much, because they're almost like a black supremacist organization, or even the Nation of Islam, even though I like a lot of their teachings and everything. But some of the things I try to stay away from because I'm trying to elevate to a higher level. When you get elevate to a higher level spiritually, those things are not really significant. They're not significant. Those are things that are put in place to hinder you in your elevation. And especially when I'm in the position that I'm in and everybody calls me, white people, black people, when you start traveling the world, you're going to see everybody got the same problems. Everybody got the same problems. Everybody's the same. This racism is ridiculous. Anyway, let's keep going. Let's keep going.
Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Is that an Article 3 trial?
To what?
Will that be a Article 3 trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a problem?
Now, this was strange to me. Usually they issue a warrant for your arrest. If he ain't here, I'm issuing a warrant for his arrest. And you have a trial date tomorrow and they reset it. You understand? Are y'all paying attention to this? This is highly unusual. What? He ain't made an appearance. He said, well, if you ain't him, well, they usually, okay, well, he's not here. He ain't made an appearance. He failed to appear. What do they do with a failure to appear? Issue a warrant. But he reset the court date. Because if you look at when it changed and his attitude changed when he asked him, is that going to be an Article 3 trial? This is the whole thing that they hiding. I don't care if there's an attorney looking at this right now. They got go to him and ask the question. Watch how they start jumping and juggling and things. They can't, and nobody gonna give you a straight answer. Well, show that to me. I've been studying this for the longest. I'm looking in all kind of law books. You know, you start with analysis. I just ordered a Supreme Court analysis and interpretation of, let me give you the book. This is the book right here. You can get it on their website, but I got a copy, one version of it on my website. Let me give it to you right now. If you want to study the Constitution and the difference between Article 1 and Article 3, you should read this book. Where is it at? And I also got a lot of articles that I put up. If you go over to my PDF section, discussing, damn, did I not put it up? Supreme Court analysis and interpretation. Oh, here it is right here. Yeah. All right. This is the book that you want to study right here. Analysis and interpretation of the Supreme Court. If you go to Article 1, Section 8, Clause 9, you're going to see that it's not going to be any, it's the only chapter in this book. There's nothing right there. It says, see Article 3, Section 2. Now, we know separation of powers. So in Article 1, Section 8, Clause 9, it lets the legislature make courts that are inferior to the Supreme Court. Okay, well, separation of powers, and there are case laws that talk about this. Okay, there's no way that a legislative court or an administrative court that can exercise judicial power that is delegated from the Constitution. The Constitution created the Supreme Court, not the Judiciary Act of 1789. The Judiciary Act of 1789 created some sort of appellate court. They call it the United States Supreme Court, and they allow Article 3 judges to sit in it in an appellate capacity to appeal decisions that are coming out of these Article 1 courts. U.S. district courts are Article 1 courts. They're Article 1 and Article 3 courts. They're enforcing statutes. It can't be Article 3 courts. I don't care what you say. When a judge is enforcing a statute, he's acting ministerially, not judicially. He's following the orders of his masters, who happen to be the legislature. Now, if you're listening to me, you know I'm telling the truth. You're just trying to figure out a way to make it seem like I don't know what I'm talking about. You know I'm telling the truth. I've been doing this a long time. You don't want to open that door, Because now when we get into the civil nature of it, that means there's some sort of pecuniary interest. This is how you are selling criminal bonds and prison bonds. See, I done already been on the secinfo.org and pull up the B424 perspective of some of these private prisons and read them. It's nothing but a trust indenture agreement. And see the per diem for all the money they get for having prisoners in jail for every day they have a prisoner in jail. You're making a lot of money on it. And then here's another thing. The criminal justice system is supporting this Federal Reserve system. That's what supports the whole system. That's why they're not going to tell y'all anything. The criminal justice system is supporting all of this. They're enforcing. Where do you think the enforcement is coming from? That's why I talk about it. And I have to thank Gene Keating for that. Gene Keating, he made a document called, let me give it to you right now, Prison Treaties. If you have a case right now, it would behoove you to read this. He did more research on the criminal justice system probably than anybody. Read that one and also read this one right here, the Gene Keating transcript. This right here explains the GSA bonds, how they are bonding these cases. It's the creation of money. Money is created through debt. Everybody's looking for a way to create money. If you understand that one simple fact, you understand the whole entire system. The whole entire system is operating off of some sort of rapacious appetite of individuals to create money through the creation of debt. What better way than have a debtor's prisons? They're not going to call it that, though. I don't know if Gene Keating is still alive. So let's keep looking. So I wanted you to see how the demeanor of this judge changed once it was brought up. Is that going to be an Article 3 trial? One of the techniques that they do is they start this intimidation tactic. You wasting the court's time. Blah, 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 blah. How am I wasting my time? Wait a minute. First of all, it is my understanding that I'm afforded my right in court due process, which means that I can ask questions until I'm satisfied with the answer. I'm here to make a record. I have constitutional protections. And I'm telling you, man, if you want to see something, start talking about the Constitution with these people and see how pissed off they get. They get pissed off when you start talking about the Constitution. That right there is always, I'll be like, damn, this motherfucker. I'm going to tell you like an attorney told me. An attorney told me this. Attorney told me this. He told me this. One of your brotherhood told me this. We were talking about something, and I said to him, I said, well, what about my constitutional rights? And he did just like this. He looked around. The Constitution don't mean shit. And a chill went down my spine. Now I understand what he's talking about. The Constitution really doesn't have anything to do with your administrative courts. It doesn't. That's why the procedures are in place, and that's why you're taught procedural law in law school. The procedures are put in place to ensure there aren't any violations to the Constitution. That's the purpose of the procedures. You can read United States Code annotated at the introduction, and you can see that the approval for all those statutes and codes and everything that y'all like to talk about so much, they run it by the Supreme Court justices first. The rules of criminal procedure and the rules of civil procedure, they run it by them first. That's the purpose of them. All procedure is for that purpose, to make sure there aren't, everything in the public goes through some sort of procedure. Like if a cop kills somebody, when they do a review of it, if he follow procedure, they're not gonna do nothing to him. It don't matter what you say. That's the whole thing they want. Did he follow procedure? If he kills somebody, he follow procedure, they're not gonna do nothing to him. Because if they follow procedure, that means they're doing what they're told. If they're doing what they're told, that means they're immune. It's only when they get outside the ambit of delegated authority that they lose their cloth of immunity. That's the purpose of the procedures. Y'all need to understand that. Let's keep going.
If you put a notice up there on Penal, if we don't need you tomorrow, but we need you on February the Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry.
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me whose name must not be altered, uttered, then we will set a July 15th trial date for Mr. Aldridge. Your whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be set, will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
Well, damn. Take your piece of paper and go on about your business. I want you, this is a very interesting case because obviously somebody didn't appear. He gave him some sort of piece of paper. This is the thing. In the public, that's all for show. Obviously, he gave him something that did something. I'm not sure what it was, but he did something. He didn't speak aloud. But it's going to be Article 3 court. He gave him some sort of paperwork. Well, I'm going to just dismiss this. You know, he could have objected to that on the record, but I would think that he would issue it was a failure to appear. It should have been clear to me, but I wanted you to see that the reason a lot of times things like this, they're able to say, well, that doesn't work because the public show is never going to work in the public show. It's behind the scenes. They let you go. They just dismiss the case. It's that. It's never going to be, oh, you know what? You're absolutely correct. You are sovereign. And you're right. We are, making prison bonds and everything. They're never going to say that. This is what their arguments just seem so asinine to me. We're saying you're hiding something. Of course, you're not going to find it in any case law. But yet these people call themselves intelligent. And they make ridiculous arguments because they're trying to hide something. Anyway, that's my little review for today. I hope y'all enjoyed that. I think y'all should look at that over again and try to get some of the points. I thought this was a very strange case. Everything changed when he asked him, is it going to be an Article 3 trial? And That's always been my contention. That's always our contention. That's the only question we're asking. And you will see time after time again, they were not going to answer this question. That's my point in doing it. He never answered that question. He didn't answer that question. He went right past it and started directing him into something else. As a matter of fact, you're wasting the court's time. You know, you're filing this ridiculous paperwork. It's all an act. It's all an act. It's all an act. It's all in that. The most important question you can ask a judge is what jurisdiction you're operating under. You don't have to challenge jurisdiction. I'm not here to challenge it. I can challenge it after I find out you tell me what it is. I don't know what it is right now. Statutory jurisdiction, you know what, Yana? I'd be more than happy to accept that. However, I haven't been able to find any information about a statutory jurisdiction. Could you please direct me to where I can find the published rules of criminal procedure for a statutory jurisdiction? Do you have a copy of it? Could you provide me a copy of it? You must provide it to me. I'm representing myself. I have a right to represent myself according to the Sixth Amendment. And in order for me to effectively represent myself, I need to know the nature of this action. Because the rules of criminal procedure under a common law jurisdiction are different for the rules of criminal procedure under Admiralty Maritime. And you just said this is a criminal action. It's simple. Some of the most simple things. It took a lot of research for people to find out that information. And a shout out to Howard Freeman. He's dead, but it wasn't just him. It was other individuals too. There are people got out of prison with it. I just seen somebody just get out of prison with it. I'm gonna see if I can bring him on the show. I'm just kind of letting them, they settle in. They just got out about a week ago, but they wanted on appeal. The judge didn't tell them the nature and cause of the action. They had to come and get them out of federal camp. They at home. Case, everything vacated. They worried right now because they've been in jail. That means there's some liability that they don't want to really let go of right now. But anybody knows when they let you out of federal prison, somebody fucked up. Somebody fucked up. They let you out of federal. They don't just let you out of federal prison. Anyway, let them keep on saying this is ridiculous and, you try that and, you're going to get arrested and all of that. And what I say to that is go get you an attorney. They got a 98, 99% conviction rate. Go get an attorney. This is what's going to happen. He's going to give you a plea deal. You're going to take it. You're going to either get probation or you're going to prison. Go get an attorney. Go get one. Don't matter if you're innocent. Because if they charge you, as long as they indict you, your chances, even if you are innocent and they'll have no evidence, your chances while using an attorney of getting out that is almost slim to none. They got a 98, 99% conviction rate. Majority of that coming from plea deals. All I've ever seen is these motherfuckers do plea deals. That's it. That's all I've ever seen. That's all I've ever seen. That's all I've ever seen. You see a few little cases like with Johnny Depp, but Johnny Depp's Jewish. Let me tell you something. That Johnny Depp case, I knew he was going to be innocent. I already knew. When I found out who he was, I'm like, they ain't finna get, old girl ain't got a chance. She a white girl too? Got a chance against, don't matter. We ain't have a chance. Anyway. That's it. Like, comment, and subscribe if you like this. I appreciate all of the, what is somebody just donated to me. $2.99. They won't reveal the origin of the indictment. Herman CZ, thank you for the $5. Welcome to Neophyte. Let's see what we got. What else we got in? I know we had another person in here. John Q. Public, $4.99. Can you review James Freeman's video? He was up where the sovereign operates the judge. He was very on point with how you approach the script. Okay. James Freeman's, I'll look at it. I will look at it. I think I did look at his. Tyrone Cherry, thank you for the $10. Thank you for sharing your knowledge. I appreciate it, brother. Appreciate you. Thank you so much. And thank you. I can't go back and look at everybody who donated, but thank you. Like, comment, and subscribe, and I'll see y'all tomorrow. I'll be on tomorrow, same bad time, same bad channel. This week I am doing, I know I keep telling y'all I'm going to do classes on SBC University. I've just been so busy traveling and doing a lot of things, but I am going to be doing trust, 22 days of trust, and then on the weekend I'm going to do secure party webinars. All right, we got to get deep into this trust because I got to start teaching y'all that, and that's about it. Peace to the gods. You've been listening to the hottest radio network on the planet. Like, comment, and subscribe. Let me know what you think about this video. Peace. I'm out.